with us. He is a graduate student and he is a teaching associate in business law also. So he usually comes to my class to take classes. We are here to discuss about the Personal Data Protection Bill, which is under consideration in the Joint Parliamentary Committee. So let's go into the show.
I understand, Adhvaith, we are meeting in a strange atmosphere. We usually meet in class and discuss about topics in the business law, but here we are in a different atmosphere, hosting a talk show on behalf of the university, and I appreciate your team and your efforts for bringing up this topic and working on it and hosting this talk show. So here we are to discuss about the Personal Data Protection Bill, which is going to most significantly affect the lives of the public. So what have you got for me?
Yeah, I'm really excited for this and I have a few questions for you.
Yes, please.
Yeah, my first question will be, right to privacy is a fundamental right, and this bill aims to secure the rights of the people, and we are reading some new rights like rights to be forgotten and all. How far will the contents of the bill reach the people, and how far will the people be aware of that in our today's society?
Right to privacy was conclusively held a fundamental right after the Puttaswamy judgment of 2017. Till then, we had been debating about whether it is actually a fundamental right or what is privacy actually and how does data affect the lives of an individual. So we had been debating about it, and still people are unaware of what personal data actually means to them. We are totally unaware about this technical field, and say for example even about the applications which we use in our mobile phones. Reports say that the applications which we use in India require 45% more permissions than what it actually requires in other countries. The conventions like the EU GDPR have a strong regulation over these applications than the provisions of the bill which we are discussing here. So a committee was formed in 2018 which proposed a draft data protection bill. The provisions of this very same bill establishes a data protection authority which is supposed to create awareness about data privacy and protection of personal data. On behalf of our department, we are mooting for sharing this responsibility with the private data fiduciaries and processor. Creating awareness need not be only done by the protection authority, which is data protection authority which is being set. It can also be shared along with these private parties and businessmen who handle personal data of the individuals. Beyond that, we as individuals need to take agency of our own rights and use technology more carefully. We need to be more disciplined while using technology for our own needs and benefits.
Yeah, but how are we supposed to understand all these terminologies and jargons when they are so complicated, like explicit consent, sensitive data, critical data, data processing, data fiduciary? We don't understand most of these things, and how are we supposed to be disciplined? These things are not put into layman's terms, so we don't understand it.
I understand your concern. I agree with you that the terminologies used in the provisions of the bill are complex. They tend to be jargons and cannot be understood by a common man whose personal data this law is aiming to protect. I feel that this is mainly because of the colonial tradition we had been following with regard to formulating law and policies. I'm not saying that there is something wrong with the system or the people who formulate the laws for us, but it is the style in which this language of law is being used is making it more complex as such. This is what happened to this law as well, making it more complexly worded or structured. When we compared the EU GDPR with the Personal Data Protection Bill, we found that the terminologies used in it were more simpler and straightforward in conveying what it actually wanted to. Say for example, the 11 data subject rights, when read by any individual, clearly tells that person what his entitlements are. And we feel that this is what is the problem with our data protection bill, making it more complex and not easily understandable. Why take the EU GDPR? Take the contracts or the terms and conditions of Google or YouTube, which are way more easier, simple and straightforward to understand for any person. So when you take a law which is protecting your privacy and another contract which asks for the terms and conditions of usage of your personal data, the one which is supposed to be more simpler and easy to understand by a common man is way more complex in explaining what an individual's rights and entitlements are.
But we still have to deal with all these terminologies, right?
Yes, we have to. On behalf of our department, we are sending out the comments on this data protection bill to the government, expecting some change in the provisions of the bill with regard to the terminologies used, which will make it less complicated. One of the initial suggestions that we would make would be with regard to the reductionist approach towards the term of processing. The term processing as defined under the bill includes various activities like collection, use, storage, structuring, organizing, erasure, deletion, and even dissemination. I hope you understand that activities like dissemination or deletion involves a very high threat to an individual's data. On the other hand, activities like collection is where the very first intrusion into an individual's privacy starts with. Even the Puttaswamy judgment says that collection is one of the most important activities when it comes to processing. But we don't see a difference between these activities when all these distinct activities are clubbed under the single term of processing. What we feel is that classifying these distinct activities under 4 main groups would make it more simpler and easily understandable to a common man. We suggest that these activities be grouped into collection related activities, storage related activities, analysis related activities, and dissemination related activities. This actually provides the scope for the law to list out the rights, responsibilities, and also the protection measures which can be adopted at each of these different stages in a more clear way. This also provides the individual to provide consent, if not at least to the each and every distinct activity, at least to these 4 main categories, he can provide consent, whether he wants to provide consent for dissemination related activities or to the storage related activities. So this makes the process easier, simpler, and also better for both the parties, like the data principal as well as the fiduciaries and the processors. Now that we have classified the different activities of related to processing, let me just tell you something about collection related activities. When it comes to collection of personal data, it is the data fiduciary which determines what data is necessary for processing. So when a data fiduciary claims such and such data to be necessary, a consumer cannot deny consent to it, and denial of such consent, the service provider, who is the data fiduciary, may not provide that service. Say for example, a private application providing you banking service. When it requests access to your media, photos and galleries, say for keeping a wallpaper of yours, you have to provide access to the permission requested by that application. In case you deny such consent, saying that it is not necessary, you may not be provided that banking service by that application. So do you think that what is necessary should actually be determined by the fiduciary here? So even though if it is determined, shouldn't a consumer be given an opportunity to contest what is necessary as determined by the fiduciary? So that is when we put forward another suggestion by saying that it should not be the doctrine of necessity guiding this, but it should be the doctrine of essentiality, which is establishing a standard and a higher threshold when compared to being what data is necessary for processing. Our suggestion with regard to this would be that instead of the data fiduciary determining what is necessary for providing a service, we expect to establish a higher standard of essentiality in processing of personal data. So this would also give the consumer a remedy or an opportunity to contest against such determination of necessity by the data fiduciary. Another issue with regard to complexity of language being used in the law is when 2 standards of consent is being established, one being explicit consent and the other one being just consent. For one set of data, we require explicit consent where the data principal needs to be informed about the significant harm to the data principal in processing of such data. And there is another set of data where he need not be informed about the possible harm in processing while processing such data. So does that mean that a data principal may not face any significant harm while processing of this set of data? And you know how lawyers argue in courts, they just turn things around. And what I just told you about significant harm is just one example. The differences between these two, consent and explicit consent, is way too elaborate in the provisions of the bill. So here a suggestion is that there should be a single standard of consent which is easy and simple to understand. This should also provide the data principal the confidence to provide consent for the data processing activities. Over and above this established standard of consent, if there is any requirement for specific fields such as in provision of health services, let the technical authorities of those particular fields decide what more is required than the established standards of the consent which we are discussing about. Within the provisions of the bill, let us not just create confusions.
So now, Mohan, you're talking a lot of things about lawyers, concerns, courtroom procedures and all. Does this bill have anything special about dispute resolution?
Yes, it does. The provisions of the bill tries to establish a trust-based relationship between the data fiduciary and the data principal, and that is why they call it a fiduciary relationship. Back in the GDPR of the European Union, they have the data subject and the data controller, and they don't establish a fiduciary relationship. So that is when at the first point of grievance redressal is handled very internally between the fiduciary and the data principal with the appointment of a data protection officer. So every significant data fiduciary is mandated to appoint a data protection officer to solve the matters internally within them. So if the data principal feels for her privacy concerns or finds out that there is a personal data breach, he or she can approach the data protection officer who is appointed by the data fiduciary and try to solve the matters internally. If he or she is not satisfied with the solution provided by the data protection officer, they can approach further or appeal further to the adjudicating officer who is appointed by the data protection authority. In case if the individual is not satisfied with the judgment or decision by the adjudicating officer, they can appeal further to the appellate tribunal who is also appointed by the data protection authority. The problem with this grievance redressal mechanism is that the time taken for a data protection officer to respond is extended to a maximum of 30 days. Considering the technological developments in today's world, 30 days is too much to affect your right to privacy in a more significant way, and obviously the fiduciaries may take advantage of this situation and respond in the last minute, which will prove disadvantageous to the data principal in giving 30 days to the data fiduciary or the data protection officer to respond to his or her concern. So there is a need for provisional measures to be established by the bill pending the judgment of these authorities like the data protection authority or the data protection officers or the adjudicating officers. Personal data breach is a continuous process, right? So we cannot wait for a decision to be taken by these people in order to come and control or stop from such a thing to happen. So there should be some provisional measures which are taken in order to stop this. And considering the vast population of a country like India, the bill is also not clear in laying out the places of location of these tribunals or where will these adjudicating officers be placed. We feel is that it would be better for these adjudicating officers to be placed in every district and for a tribunal in every state, so that people will have access to these grievance redressal system at a higher level, not only with the fiduciary but also with the adjudicating officers as well as with the tribunal. Every individual, if a tribunal is being established just in Delhi, an individual living in Kerala or Chennai or somewhere in the northeast may find it very difficult to approach to the tribunal and may not get the redressal which he or she aims for. For example, we have something called as the green tribunals which are currently established at 4 or 5 places across India. So a person from Trivandrum or say Alappuzha is facing some environmental concern and wants to express himself in these tribunals, which the closest one being established at Chennai. He or she may not be able to do so while in going there physically and representing her concern and getting her concern redressed. So such physical difficulties or access to these tribunals or the services of these adjudicating officers should be made easier so that the data principal gets the maximum benefit out of this grievance redressal system.
Okay, now Mohan, thank you so much for sharing all these things with us. Do you think anything else is really important about this bill we need to know?
Yes. Throughout this talk, we had been discussing about protecting the rights of an individual, that is the rights of the data principle as such, but we also need to speak about the state, the government as a data fiduciary. If the government acts as a data fiduciary, it is for the benefit of the entire nation, but the state cannot handle such huge amounts of data on its own. It doesn't have the resources to. So obviously it would contract out this process to a private data processor. So the relationship between state as a data fiduciary and private data processors is often limited to a contractual agreement which these both parties enter into. And in most of the cases, the private data processors tend to reduce the liabilities which lie upon them, and it is the state as a data fiduciary who is solely held responsible for the activities of processing, even financially. Most of the times, because of the technological advancements available with these private data processors, they tend to have a higher bargaining power when it comes to the terms of negotiation with the state. Also, there are no provisions regulating the contractual relationship between the data processor and the fiduciary in our law. When we look into the EU GDPR, there are clear provisions which regulate the contractual relationships between the processor and the fiduciary, but such provisions are seen to be absent when it comes to our law. It is very important to incorporate such provisions into the new bill, or else it would be like leaving the state to the negotiating skills of the clerks or personnels placed in various departments getting into contractual agreements.
Thank you so much, Navamohan. You have brought in a new aspect. Normally, when people talk, we only talk about the entitlement of the rights. We don't talk about the process of governance. Now we have brought in a new aspect. I am more thankful to you.
You're welcome. The very intention of this talk is to initiate a discussion in the public sphere. Topics like this go unnoted because they are felt less sensitive, and the media spaces too don't cover these topics. But these topics affect the lives of the people more significantly. And let us participate. Let us make it our duty to participate in the lawmaking process, be it in the state or at the center. And I am looking forward for you and your team to come up with another discussion on a new topic or a new bill. Of course. Thank you.